Trial Skills Bootcamp Series CLE on jury charges and preserving error. Before we get started, the course number is 174097829, and it has been approved for one hour of CLE credit. Again, that number is 174097829. You will need to self-report to the State Bar of Texas to get CLE credit. Should you have questions during today's program, feel free to use the Q&A function located at the bottom center of your screen. I'm George Pattis. I'm an Assistant United States Attorney here in the Northern District of Texas and the Trial Skills Bootcamp Committee Vice Chair for CLE, or in the year of COVID, the Vice Chair of Zoom. We're excited to be joined today by a truly outstanding panel with deep experience on today's topic, jury charge conferences and preserving error. Justice Ken Mulberg from the 5th District Court of Appeals, before being elected in November 2018 to the appellate bench, Justice Mulberg was a trial judge in Dallas County District Court for 10 years. He also previously served on the Texas State Bar's Pattern Jury Charge Committee and co-chaired its subcommittee on labor and employment law. Leslie Shigaris is a partner at Reese Marcados, where she has tried numerous civil jury trials to verdict and has not ever lost a civil jury verdict. Among other accolades, Leslie was named Super Lawyer Rising Star for each of the past 5 years, culminating in being named DAYL's Outstanding Young Lawyer for 2020. Morgan McFeeters is an appellate lawyer focused on civil appeals and supporting trial lawyers. She has handled numerous appeals and routinely assists trial lawyers in briefing and arguing various substantive issues, including pertinent today, jury charges. Morgan currently serves as a member of the Advocates Committee, Board of Directors for the Texas Trial Lawyers Association, and the Board of Directors for the Dallas Trial Lawyers Association. Finally, David Cole is a partner at Lynn Pinker, Hurst, and Schwegman. He has been recognized as one of the top appellate lawyers in Texas. He is a frequent commenter on legal issues and publishes a popular blog about commercial disputes before the most important appellate courts for Dallas litigators, including the Fifth Circuit, the Texas Supreme Court, and the 5th District Court of Appeals. He also hosts a podcast called The Cole Mind about legal analysis, current events, the Supreme Court, and constitutional law, which is available on Apple, Spotify, and wherever else you find your podcasts. For today's program, we'll begin with a brief introduction by Justice Mulberg, explaining the basics about what a jury charge conference is, the court's role, and the difference between an informal versus a formal charge conference. Following that, Morgan McFeeters will portray plaintiff's counsel, and David Cole will portray defense counsel in a short mock formal jury charge conference with Justice Mulberg presiding, based on the 2020 hypothetical. After that, we will have a panel discussion about jury charge conferences with answers to the questions posed in the Q&A feature at the end if time permits. So to start things off, Justice Mulberg, what is a jury charge conference?
Well, the jury charge conference, George, is where I view it as where it all comes together. Everything that you have done prior to get that lawsuit together, to discover it, to bring it to fruition, to bring it to trial, the charge conference is where everything coalesces. It is what I believe is the most important aspect of anything more than just your routine case. It's where you assemble in final form, obviously, the questions you'll be submitting to the jury, the definitions and instructions that go along with that. And it is really the centerpiece of the entire effort that you have made from the time you filed the original petition till the time the verdict comes in. There are various rules governing that, but anyone who faces serious charge conferences in a serious case, in which is most cases, needs to familiarize themselves with rules of Civil Procedure 271 through 279, and of course the law interpreting those rules, because it is fraught with peril. And on the other hand, it is where you can really sail and make your case once you present it to the jury in your final argument.
And lastly, Justice Smallberg, today we're going to see a mock demonstration of a formal charge conference. What's the difference between a formal charge conference and an informal charge conference?
Typically what happens, again, unless it is just a routine matter, but typically what will happen is throughout the trial court will discuss with the parties their view of what should be submitted to the jury and why. Those informal conferences may be very extensive. They may include discussion of precedent, providing the court with precedent, arguing your view of the charge or what should be the charge. And that all precedes the formal charge as described in Rules 271 et sec. And these are things that make the final charge conference, the formal charge conference, very often go very swiftly.
Great, thank you. Now that Justice Mulberg has described the formal jury charge conference, he will act as the presiding judge over our mock formal jury charge conference for the 2020 hypothetical. Attendees have received those materials. You've received the hypothetical fact pattern and the draft jury charge that will be under discussion. There's a link in the chat window if you did not obtain that already. Here's a brief summary of the facts in case you didn't get a chance to read that. The Queen of England, despondent about her estrangement from her granddaughter-in-law, had been drinking at a Dallas bar late into the night. On the way home, her limousine collided with an Aston Martin belonging to her beloved grandson on the corner of Cedar Springs and North Pearl Street. A bystander observed an elderly woman jump out of the limousine's driver's seat and scramble to the passenger side door. When the police arrived, the Queen's chauffeur said that he had been the one driving and that he had ran the red light because the Queen required urgent medical attention. Larry, the plaintiff, was driving the Aston Martin, and he claims the accident exacerbated an old horseback riding injury, and he will now require lifelong steroid injections into his back. He is suing the Queen for physical pain and suffering, mental anguish, physical impairment, disfigurement, loss of earning capacity, and exemplary damages. He is also suing the chauffeur. At the formal jury charge conference, Morgan McPheeters is representing the plaintiff, Larry, and David Cole is counsel for the defendants, Her Majesty, the Queen of England, and her chauffeur. Justice Mulberg is presiding.
All right, counsel. Let the record reflect that we're inside the courtroom, outside the presence of the jury. The court has tendered to the parties its proposed charge that it will submit to the jury in this case pursuant to the rules. With that, I'll hear from counsel. Ms. McPheeters.
Thank you, Your Honor. May it please the court. As the court's aware from our informal charge conference, we first take issue with the emergency instruction that has been improperly included in the definitions within the court's charge. And this is found on page 3 of the charge. An emergency instruction is only properly included when there's evidence that there's some sort of emergency that has come up unexpectedly and that it has nothing to do with the negligence of a party. Here, presumably the defendant wants to include this instruction because they contend that the Queen's vehicle ran the red light because of some medical emergency. However, the evidence has demonstrated that any such emergency or any context here did not arise suddenly or unexpectedly. And additionally, the evidence showed at trial that to the extent the Queen was suffering some kind of condition, it was due to her own negligence, as the evidence demonstrated that she was drinking heavily through the night. So this inferential rebuttal instruction—
Counsel, is there any evidence that the drinking, the Queen's drinking, in any way contributed to the emergency? I mean, I do have testimony in front of me that there was a sudden a medical condition involving the Queen. So the fact that she had been drinking, unless it is somehow tied to it, what would I do with that?
I don't believe that the evidence showed that that this was some sort of completely unrelated medical emergency. There was some discussion and testimony that there was quote unquote breathing issues. However, I think that the evidence here shows that her negligence contributed to whatever she was experiencing that night at the time of the occurrence. Therefore, this instruction really has the potential to skew the jury's analysis here in favor of the Queen, and we would ask that it not be included. And so for those reasons, plaintiff objects to the inclusion of the emergency instruction on page 3 of the charge.
Mr. Cole?
Your Honor. This is a pattern instruction. There is evidentiary support for it. There is testimony actually even uses the word emergency. The question is not whether or not she was actually sick. It is whether they were under the reasonable belief that there was an emergency and were acting in accordance with that belief. Ms. McPheeters' closing argument is eloquent on those points, but it's not a charge submission question. And they've already are pushing the envelope on the rest of this causation instruction with some of the things they're requesting. It's only fair that we get an inferential rebuttal pattern form if there is evidence to submit. It is appropriately included in this charge.
Anything further?
I think the key, Your Honor, is that this instruction cannot be submitted if the emergency that arises is due to the negligence of that party. So I would again re-urge our objection here.
You didn't ask to get sick.
Your objection's overruled.
Thank you, Your Honor.
Endorsed.
Our next objection, Your Honor, is to the damages question, which is question 3 of the court's charge. Oh, yes, question 3, I believe. Now, our issue here is we object to the inclusion of the 2 elements of damages, physical pain and mental anguish, are being submitted on the same damages line within the question for damages. Now, the PJC currently in the damages question includes these on the same line. However, in 2018, the PJC committee did add a caveat in their comments to this question, cautioning strongly the submission of these 2 separate damage elements on the same line. So Texas Supreme Court case law from Castile on holds, and it's well established, that when you're submitting 2 different elements of damages, they need their own separate line. The jury needs to be able to consider them separately. Physical pain and mental anguish are 2 different concepts that would compensate 2 completely different types of harm. Physical pain is the conscious physical sensation, whereas mental anguish is a mental sensation due to what the plaintiff has suffered. So under Castile, this would be an improper submission to include them on the same line, and would result, if there is a question that's taken up to the Court of Appeals as to whether or not there was sufficient evidence to support this damages award, it could result in the Court of Appeals not being able to tell what the jury awarded damages for. Was it for physical pain? Was it for mental anguish? And in that context, it would require reversal and a new trial in order to remedy that. So here we would object to this inclusion of physical pain and mental anguish on the same damages lines. And I'm tendering to the court what would be the proper submission, breaking those elements down into their own separate lines.
Mr. Cole, let me hear your response to that.
To be fair, this is one that's kind of out in the gray area of Castile questions. I think the court probably has discretion in the form it uses here. I think the court should exercise its discretion to follow the pattern charge, though, which, as Ms. McPheeters correctly points out, has not been revised. I think the reason for that is that you only have a Castile issue if there's a serious question of there being no evidence. And we have someone here who says they were hurt, and we have someone who says they suffered anguish, and that's why this type of submission hasn't produced Castile opinions, and why I don't think it's likely to produce one in this case. We also have guidance and a warning from our Supreme Court not to over-granulate, that's the Hyundai case, building out of Castile, and indeed this exact charge involving the submission of these two things on the same line was in front of the Supreme Court in the Harris County case that first applied Castile to damages. Admittedly, this sentence was not under the court's scrutiny, but it was there when they were discussing the issue, and it didn't seem to trouble them. So I recognize there is at least some theoretical risk of a Castile problem here. I think it is only that, theoretical, and that in the absence of something more tangible, we really ought to just stick with a pattern submission and not create a test case where we just don't need to be doing that.
Well, you defense lawyers are just enamored of that Castile stuff, aren't you?
It makes my heart beat rapidly whenever I hear the name, Judge.
Yeah. Okay. All right. Ms. McFeeters, your objection sustained and your submission is granted, and it's so endorsed. Next.
Thank you, Your Honor. That concludes the plaintiff's objections to the charge.
Mr. Cole.
Yes, Your Honor. Question 3 of the charge, it proceeds with the usual sorts of things until I think it's the 4th paragraph, but we get off on this eggshell skull thing. That is not from the pattern instruction, nor is it from this millennium. The case law cited is from back in the 80s. The law has moved since then. This notion of an eggshell skull for charge submission is subsumed within the general causation instruction. To now come back in 40 years after the fact and drop in this Prosser and Keaton on torts business is an unfair comment on the weight of particular evidence. It will skew the jury's deliberation and throws out of balance the careful phrasing of the general language of causation is used throughout the pattern charge and has been for several years now. There is a place for this kind of argument about the structure of court law. It is in sufficiency review after trial. It is a pure statement of law, however, that has no business being in the submission of issues to the jury, and putting it in there skews that submission away from the carefully crafted proximate causation instruction that we've all used without issue for many years. It should not be submitted, and I object this paragraph of eggshell skull instruction to the jury.
Ms. McFeeters.
Your Honor, although this language did not come directly from the pattern jury charges, it does track language that the Supreme Court and courts that have followed it, including the Dallas Court of Appeals, have approved in terms of the eggshell plaintiff rule. This is a long-standing, well-established rule in Texas. The defendant has to take the plaintiff as they find them. Here, there's evidence that Prince Larry had this prior injury and that the occurrence in question in this case exacerbated and made worse his injuries because of that. That he had this prior injury should not result in a windfall for the defendants. They are responsible, nonetheless, for making those that prior injury worse. I think the court can safely include this instruction because it does track the long-standing statement of this rule by the Texas Supreme Court.
It's a long-standing rule, but that'd be it's a long-standing part of the charge.
Well, you know, the Supreme Court, Ms. McFeeters, has warned us that you know, we're not to over-instruct. That's one of the beauty parts of the Texas charge practice. Your objection sustained, counsel.
Question 1, we have previously discussed the submission of the sudden emergency instruction. For the same evidentiary reasons, I believe it is appropriate to also include an instruction on unavoidable accident. The Queen did not ask to be sick. There is evidence on the point, and the submission is the standard form submission. So I think it would be an appropriate addition to the jury's deliberations on this point, particularly since they're already deliberating on the matter. So I have prepared a form submission. It follows the pattern charge. I'm prepared to offer that to the court once we've heard from opposing counsel.
Ms. McFeeters.
Your Honor, for many of the same reasons as previously discussed, we would object to this inclusion of the unavoidable accident instruction. Under the PJC, it talks about that this instruction should only be submitted if there is evidence that the occurrence was caused by unforeseeable non-human conditions. Again, here, the occurrence was caused, at least in large part, by the Queen's own negligence, her heavy drinking that evening. there's no evidence that there was some unforeseeable non-human condition here that caused this. So therefore, we would ask that this not be included and object to the inclusion of the unavoidable accident instruction.
Mr. Cole, you're getting two bites at the apple here. I mean, there are cases that say that these are two species of the same genre, so to speak, the same class.
Yes.
I don't. You know, it seems to me that sudden emergency is just a more specific form of unavoidable accident, and I think there are cases to that effect.
May I offer the court my form of submission for it to take and endorse its ruling on?
Okay. Well, your submission is refused, and it's so endorsed.
Thank you, Your Honor.
And
my final objection is on question 1, about halfway down the page. This is also in the definitions section that precedes it. The definition of high degree of care, which is offered in the context of defining the liability standard for this case. I get it. This is the plaintiff's issue. It's their claim. It's the burden they're taking out for themselves. But the chauffeur, private chauffeur, just isn't a common carrier. This is a standard created in the cases because of the unique issues associated with people that open their trains and buses up to the public. This person is private. They have their own contract. There's not a case or a policy reason to have this be in this charge. It's their burden. I understand that, but there's a real risk we're all going to be back down here trying this again if this goes in, because there is not a foundation in the law of this state to submit this kind of question for a private limousine driver situation.
Ms. McFeeters, is a practical matter. Well, first of all, what's the basis for this?
So first of all, Your Honor, this instruction comes directly from the PJC, so the wording is proper in terms of that. You know, Texas law imposes a higher standard for common carriers. And although we might think normally in terms of buses or shuttles or something like that, there is Texas law, case law applying this standard also to taxi cabs, for example. And here, I would argue that that's a similar context. We have a private driver who is driving the Queen around, and that's similar to a taxi cab, although it's obviously not a bus or anything like that. So here, there's evidence to support inclusion of this instruction, and it should be included in addition to the ordinary negligence standard, because we've got to ask the jury about these two different levels of negligence.
Well, you've been watching the case law like I have over the years, and you probably looked at some of the high degree of care cases and how they're not in particular favor right now. But as a practical matter, if I give you this and you get a finding in your favor on this, you need to think about whether or not you're going to be making some bad law on appeal. So I'm going to sustain the objection.
That concludes our objections, Your Honor.
All right, counsel. We'll have these revisions made. I'll get a copy of the charge made for every juror. You'll have 2 copies apiece, and we'll get to the argument in about 15 minutes.
Thank you, Your Honor.
Thank you, Your Honor.
All right, well, thank you all for a terrific demonstration. We hope that today's demonstration will help ground and inform the panel discussion that follows. Justice Mulberg, to start things off, what are some of the basic strategies and goals that lawyers should be thinking about for jury charge conferences?
Well, your strategy is to get your best case on paper before the jury, and where you do it is in the charge. The goal is to make sure you have evidence in the record that will allow you, entitle you to a submission and an instruction or definition that is totally aligned with your case. One of the points we have made here, and we'll get to it a little bit later, I'm sure, is that the Texas system is a very integrated system from voir dire to opening statement to the trial itself to the final argument. And it all really should revolve around the charge, or what is going to be contained in the charge. So your strategy is a long-term strategy. and it is to get the most correct and proper submission you can that is most favorable to your side.
And then we should have covered this earlier, but you mentioned in the demonstration that argument was going to follow. When does the charge conference occur, both the formal and the informal, typically?
Well, the informal, there's no set time for those. I have been known to, when I was on the district bench, to be communicating informally with counsel at 1 o'clock in the morning on the charge in very complex cases. And some of you on this panel may have been victims of that. But they occur throughout. And, the charge conference is going to occur after the close of the evidence and before final argument.
Great. And then in terms of strategic considerations, David, as an appellate practitioner, what are you kind of thinking about going into the charge conference?
Well, there are two distinct big picture goals. One is to not foul everything up and have to be back trying it again in a year. And so there are issues that can come up with the charge that are just sort of global housekeeping issues that you just need to help tend to. The classic example is a conditioning question that goes to the wrong place. I mean, that no one wants that. No one wants question 5 to go to question 10 when it should be question 8. And so no one wants a damage question that's just goofed up, it's organized incorrectly. So you have to keep an eye out for that kind of thing, be candid about it when it comes up, and the judge and the other side appreciates that, and then that sets you up to argue about advocacy for good questions and instructions on your issues. There's sort of an unwritten rule of charge submission that if it's your side of the case, you get some extra leeway there. If I really think I can get the extra, if I can prove that extra standard and I act like it and really believe it and there's some evidence, I may get that. I may get the benefit of the doubt, no matter how strenuously the defense lawyer argues against me, and vice versa. If I've got a defensive issue and plaintiff doesn't like the way I'm submitting it, well, tough luck, it's my issue. And so you get some extra latitude there so long as you've got the evidence to back you up. But those are the two goals. Avoid case destroying foul up, try to deal with that, and try to do as much advocacy as you can, as allowed by the law and the record that your colleagues have developed.
And Leslie, from a trial lawyer's perspective, what are kind of your strategies at the charge conference, since you're going to be the one arguing the jury charge to the jury?
Yeah, absolutely. I think when you're either a smaller firm or maybe it's a case that's not as complex, normally you as a trial lawyer, you're handling the trial and the charge conference. But oftentimes what you see in larger complex cases, you have appellate lawyers that come over, and the mistake that can happen is the trial lawyer just passes on and says, okay, you handle this. And they go off and they work on their closing arguments. The problem is you're the one as the trial lawyer that's going to need to argue the charge and explain the charge to the jury and your closing argument. And so I think you've got to take a pretty active role in not only making sure that you craft the charge based on what the evidence showed at trial and conforms to your case, but also in a way that you understand it and that the jury's going to understand it when they go back and have to fill out that charge.
Let's talk a little bit about incorporating the jury charge throughout trial. Morgan, how can trial counsel incorporate jury charges into both pre-trial and trial?
I think it's tempting to think of pre-trial, trial in a chronological way. And so you put the charge way at the end of your to-do list, but really you ought to draft the charge first. And the reason being is the charge can be your roadmap for your entire case. So if you sit down at the very beginning, and I'm talking even before you draft your pleadings, and you draft your charge, you know where you're ultimately going when you stand up in front of the jury. So I would recommend from the very beginning, draft your charge first, and then that becomes your map for what goes in your pleadings, what goes in your discovery requests, even what questions are you going to ask in depots, what do you need to get from your experts in terms of opinions, all the way through to what evidence are you presenting at trial, what are you arguing in closing. And so I think that's the best way to make sure that, piggybacking off of what the panel has previously said, that you're not fouling something up because you've been thinking about this from day one.
And Leslie, from trial counsel's perspective, how do you use the charge before trial and during trial?
Yes, absolutely. So before trial, exactly like Morgan mentioned, you should be thinking about what am I going to have to prove at trial. So that way, when you're thinking about, from the plaintiff's perspective, kind of building your case and what kind of evidence that you need to obtain through discovery, you've already thought about what are the elements going to be that are going to be presented to the jury and you're going to have evidence on. And, you know, Morgan brought up a great point when you're thinking about experts. You know, you need to be making sure that you understand what the standard is or the right damages framework way early on in your case. So that way you're setting up your reports and all of those things correctly. So it should guide your discovery. It should guide your summary judgment motions and your responses. And help you really identify what are the critical issues that are gonna come up at trial. So that way you are navigating the case through discovery and pretrial according to that.
Great. And Justice Mulberg, how are some ways that lawyers can weave the jury charge through trial?
Well, and I mentioned the integrated process that we have in state court that leads to a streamlined charge before the jury or charge to the jury, unlike the massive charges you sometimes get in federal court. You weave the language of the charge, and let me summarize it this way. You utilize the language that you know will be in the charge. In this case, negligence would be the word, or perhaps causation, or both. And you utilize those terms, not overly so, but you utilize those terms in a way that the jury, in your voir dire, for example, or throughout the trial, or in your opening statement, in all those places. So at the end of the day, when you have a judge up there reading the charge to the jury, and the judge defines negligence, the jury is typically already familiar with that concept. It doesn't catch them cold, so to speak. And the proponent of the particular question, in this case, the plaintiff on an affirmative finding of negligence, actually, it looks like their concept, what they have told the jury all along is real. It's come to fruition. Here's the judge using the very word that I used in front of the jury as the plaintiff's lawyer. So don't forget that. Far too often I saw lawyers, and I can't imagine this happening, who never even discussed the charge with the jury in their final argument. Never gave them their proposed answers to those questions and why. And those cases did not turn out well at all.
Great. And Justice Mulberg mentioned using the charge during closing argument. Leslie, how would a trial counsel approach that? How would you incorporate the charge in your closing argument?
Well, some of it depends on how soon before your closing argument you get the final charge. I've definitely had cases where you get it and the court is reading it within minutes. And so in that case, I would still have a paper copy in front of me and walk through those questions. You know, you might have a very eloquent closing prepared about the facts and these compelling arguments that you want to get out. But the jury's going to go back there and their one job is going to be filling out that verdict. And you might think, oh, I explained this issue this way, so they'll know that means they need to answer it this way. But jurors don't. And so even if you have to walk through with a paper copy and saying, so to this question, we ask that you write yes or whatever. In cases where you have a really great paralegal or you get the charge the night before, I try to take it, scan it in, and put it into our closing PowerPoint and have the answers drop in so it's on the big screen. But you don't always have the luxury of that. But either way, it is a huge missed opportunity if you do not walk the jurors through every single question every blank for what the damages amount is, so that they can be writing those down as you're talking. And as a benefit, if the jury's writing everything down, you feel like the closing argument's going pretty well.
Great. And then in terms of the nuts and bolts, David, as an appellate practitioner, are you involved in drafting the jury charge, and how do you go about doing that?
Well, you start with the first draft and you repeat. And I like to have, in a case where I'm involved early on, a draft. It's just our stuff. And it's not a common mistake when people that just go off and start working with this. They grab something off the system, and what'll be on the system will be something like what I handed up to Judge Mulberg in our argument. There's a bunch of form language that appears at the bottom of a question about, given as modified, refused, so on and so forth. There's a place for that kind of stuff during the charge conference. There's no place for that in drafting. It's just gobbled. It doesn't serve any function. So you want to have your own draft. And if there's something you want to remember about why you've worded it a certain way, drop a footnote and put in there the case citation or the reason why, and add to it. We're going to see those footnotes except you. Believe me, your partners aren't going to look at them. The court's not going to get them. They're just for you to remember. And then as time goes on, whenever you can get their attention and get them to look at it, add a few more things in, drop a few more things out. And by the time you get to when the charge is due, before trial or whenever it is appropriate to give it to them, your draft's been through a few turns. Then drop out everything in the footnotes that's just a note to you and isn't an actual useful reference to the court, and you're good to go. You've got your draft. The other side does something like that, and you're ready to rock. Hopefully, you're not turning to it the first time shortly before the trial. You've had a chance to kind of fiddle around with something that's your draft before you start folding in stuff from the other side and objections and other issues like that.
Great. And what's kind of the difference between preparing pleadings and preparing a jury charge?
So this was touched on a little bit in our mock argument. There are a lot of important questions of law that have no business being in the jury charge. And on something that's very basic, like contract formation or the basic negligence instruction, the pattern submission on that is pretty short. A sentence, maybe a couple of sentences of instruction. And that's because that's all you need to present the issue of fact to the jury and get an appropriate answer to it. To start throwing things into a charge that are correct but not really helpful to fact finding is a misguided use of resources. That may well belong in a pleading. You may need to put it at issue, give notice of your argument, something like that. It may totally be appropriate for a legal argument, summary judgment, or JNOV, but putting correct things in a charge just because they're correct is not really the way you need to be going. That's the way error gets in and the way jurors get confused about what they're supposed to actually be answering.
And just so that the audience knows, we did ask our practitioners to include some mistakes during their presentation. So as a teaching example, we did get a question from the audience that might make sense here to address. David or anyone else, what if the cause of action is not in the pattern jury charge? How do you go about drafting instructions for that?
So there's a hierarchy of easy sells to trial judges. The easiest sell is, judge, it's right here in the PJC. That's an easy sell. Your opponent is having to argue against the PJC or arguing that it's incomplete, problem. Second place is, judge, there's not a pattern charge on this. That's because the pattern charge just doesn't address this topic. It addresses X, Y, and Z, but it does not address this cause of action. That's reasonable. Okay, they can't do everything. And I've got the two leading cases, and I put together the best I could from that. And I found some case where this was tried 10 years ago, and I think this is pretty good. Step C, the hardest sell is like I just suggested. Yeah, I know the pattern charge says that, but you better have a real good but after that. But if it's not there, just because it's not an intentional omission by them, it's just something they didn't get to because it's unusual or not litigated a lot. If you've got a couple of good cases and a good argument, it should be good to go. But you have to, the way to sell it is the pattern charge just doesn't go there. It's not they went there and they decided not to put this in. It's they just, for whatever reason, this topic is just not on their radar. And that's why I'm starting from the ground up.
Got it. That's helpful. And Leslie, how do you kind of format your presentation in terms of the items in writing that you're going to present to the court?
So it definitely depends on the judge that you have. So you need to ask what your judge's preference of how they want it submitted. We've talked about, like, for example, Judge Hoffman in particular, he has a format for more complicated cases where you submit one joint submission, and everything that's been agreed to is in black, the plaintiff's is in red, and the defendant's is in blue. So that way, as you're walking through the charge, the court can see where there is disagreement and where there's not. I found that even if a judge doesn't want it submitted that way, that's helpful for me, because sometimes you get, which I've never really understood this, but people that submit their proposed charge and it's all the definitions and then all the questions and then all the instructions, and you have to kind of figure out what goes where. And so particularly in that case, it's helpful for me to see, okay, on this issue, where are the parties in agreement and where do we disagree? But some judges, like I know Justice Mulberg, when he was on the bench, you submit your own, and because he is so well-versed in jury charges and served on the committees and helped writing the instructions, he takes it and he really, comes up with the court's charge and so really need to ask the judge what their preference is as to how you want to submit it.
Great. And during the mock presentation, we heard Castile issue, I think mentioned by both of the attorneys. David, what is a Castile issue?
It's a job security for appellate specialists. Basically, if you kind of do your glasses like this and go, that's a Castile issue, and just do that several times a day, no one's the wiser, and you can go on for years like that. However, a little more substance, perhaps. Rule 277 says, I wrote it down, in all jury cases, the court shall, wherever feasible, submit the case upon broad form questions. And the pattern charge generally uses broad form questions on issues of liability and damage. A problem comes up when you have a list of things in the charge and some of the items on the list shouldn't be there. That's what happened in Castile. There was a DTPA laundry list case, and what do you know, about half the items on the list in that trial shouldn't have been there for that kind of case. There was a yes answer to something, but you didn't know what it was to. Was it to the stuff that should have been there, or was it to the stuff that shouldn't have been there? Can't tell, got to do it over again. So within the universe of where we all ought to do broad form submission, if you have lists of things, your Castile radar should go up to see if you're potentially have a problem where if something gets knocked down on appeal, you could have an indeterminate jury answer.
All right, great. Let's talk a little bit about preparation for jury charge conferences, and maybe Leslie, you could start things off, and then we'll hear from Morgan and then David. But Leslie, how do you go about preparing for the charge conference?
So when we had our initial meeting between the group, I laughed some because what we realized is everyone does it slightly differently, and there's not one right way to do it. In fact, I started by saying you should be as organized as possible, and David said, don't be too organized. But they're both right. And so the trick for me, I normally have a binder. I tab it out based on each question. So I'll have a question, and then behind that, either the printed out or Xerox copy of the pattern jury charge that goes with it, or if it's not something based on the charge or there's an additional instruction that comes from a case law, that case. But I section them off so that way if the court does want to go in a different order or take something up out of turn, you can quickly turn to that. But I do try to be as organized as possible, particularly on a case where there's going to be, 5, 8 questions going to the jury. That's a lot of ground to cover. And you have to be able to quickly move on to the next topic and have all of those resources at your disposal, particularly in the informal charge conference.
And Morgan, what is your philosophy, and how do you prepare?
So I tend to think of it as, I agree, you don't want to over organize, and that could be bad, but I look at it as the more organized you are, the greater ability you have to be flexible, because I think especially in your informal charge conference, you know, the judge just might take things up in different order than you. Issues that you sort of thought all along might come up, maybe just end up disappearing in trial, and you just don't ever have to deal with it. And so I think being organized and prepared for your informal and your formal charge conference gives you the ability to just roll with the punches. And I think a big thing is having, you know, if you know that there's kind of a weird sticky issue that's maybe you're trying to go against what's in the PJC, or there is nothing in the PJC, you know that ahead of time. And so you know that you're going to need to come with some firepower to support that. And so being organized on that issue is key.
And Morgan, what, from your perspective, like, what does that look like? Do you have a binder too, or do you, what do you use just on paper?
Yeah, I'm a binder person. I like having everything just tabbed and organized. I might have, you know, some red ropes with case law if I know that there's going to be an argument and we're going to need to divvy up cases to the judge and opposing counsel and go through it, that sort of thing. But I prefer a binder.
And David, Leslie mentioned that you were from a different perspective. Could you explain a little bit about your philosophy?
You referred to something called a binder that used tabs, and I was not familiar with that. But I prefer a heap. This is what I had for the mock argument this morning. Each issue we're going to talk about, I have on a separate piece of paper. So here's sudden emergency. Here's the Castile thing. And so that's, and the reason for that is in case we show up for the charge conference, the judge wants to talk about damages, great. I can put damages up front. I'm not bound the way I am in a notebook to have everything in a certain order. I just take my little heaps and I move them around. And the things that are, these are my notes going this way. This way I have things I will want to refer to. Probably a copy of whatever it is in the PJC, probably a copy of the case, this argument, my forum unavoidable accident instruction. And so I've got that turned this way so it doesn't get in the way of the notes. And with that, I mean, you can sit there and rearrange the order or throw away or add authority very loosely and very quickly. And I think that setup enables you not only handle whatever may get thrown at you at the formal charge conference, but during the course of the trial, as people want to talk about the charge, you can grab the chunk of things that's most relevant to whatever is being discussed and kind of roll with that and then put it back in without throwing off a bigger scheme. But I respect notebook people. Some of my best friends are binder people, and you know, I get that. So you're all right too. There's different ways to do this.
Those piles the piles really stress me out. But you do you, David.
They give me joy. I feel like I have a friend with my piles.
And then Justice Mulberg, I want to get kind of the perspective from the bench. What is the court thinking about heading into the charge conference, and what are some of the differences you've observed in the preparation of attorneys, good and bad?
Well, let me just endorse both methods that we've heard about here. They both work because preparation is the key. One thing we haven't talked about is the preservation of error and the fact that the charge conference is fraught with a lot of danger for the inexperienced. A lot of things can happen there, and a cagey judge can pretty well take advantage of you if you don't know what you're doing and you're not prepared. But you need to be prepared not only to do these things that Morgan and Leslie and David have told us about. You need to be prepared to preserve error. You need to know the law that applies generally to any charge conference. That is absolutely essential. So together with that type of preparation and the preparation that the others have indicated here, those are your goals. Those are your goals.
And Justice Mulberg, you mentioned, cagey judge might take advantage of an unprepared attorney. What does that look like? What are the consequences of that?
Well, the word is waiver, generally. If you don't object or submit at the right time in the right way, very often you're going to waive a point of error on appeal. And that can be very, very serious at times.
Great. You mentioned inexperienced lawyers, and I thought, we're the Association of Young Lawyers, so we certainly have a lot of young attorneys watching. Morgan, how are ways that junior lawyers and young attorneys can be most helpful at the charge conference?
So one way that I think a younger, newer lawyer can be really helpful is with preparing ahead of time trial briefs. If you know early on in a case, which is often the case, these things often aren't a surprise that, pops out for the first time in your charge conference, that there's going to be a particular issue, you can be prepared ahead of time with a trial brief on that issue, file it with the court so that everybody knows what the arguments are. You can have your best shot at persuading the judge to go with you. These you can identify them early on. They often come up in your dispositive motions. For example, also the submission of the pain and suffering and mental anguish issue that we talked about in the demonstration. If I know going into a charge conference that that's going to be an issue, and if I have a suspicion that the defense counsel is going to object to that, or if I know that this court in particular does not submit things on separate lines, I would probably file a trial brief just laying that out. And so a younger lawyer can really be helpful in that way. They might not be up there arguing the charge themselves, but that's a great way to be involved and show some value by researching those issues and having them all teed up early on.
Great. And Leslie, what about from your perspective? How can junior lawyers get involved at the charge conference?
Yes, I think there are a lot of ways, and actually I see this often as a missed opportunity, especially in the informal charge conference. The young associate or associates who are on the trial team, they take off and they're not in the room. And there are so many ways. Well, one, you should be there because you should be learning how it, the process plays out, even if you're just sitting in the corner listening and observing. But two, there's a lot of really good ways to help. One in particular that I've seen is a lot of times, as I kind of mentioned earlier, some practices are they send in the appellate lawyer and the trial lawyer goes off and works on their closing or the witnesses for the next day, what have you. And all of a sudden there's an argument or dispute over a particular question or an instruction. And if you are the one that has the trial counsel who's been there, you can say, well, judge, remember, so-and-so witness, he testified on Tuesday and he said this. And the appellate lawyer, if they haven't been in the trial the entire time, they're going to be at a disadvantage. So if you're at a bigger firm in particular, where you have a large trial team and you have an appellate lawyer coming in, as a young lawyer, what you should be thinking is, how do I update the appellate lawyer at the end of each trial day, either by some notes or summaries, and then how do I meet with that appellate lawyer before the charge conference so I can let him know if there was anything that came up in the evidence that's going to be probably key at the conference. I also think something that is a pet peeve of mine, but happens a lot, and not to pick on appellate lawyers, but we'll go through the whole informal charge conference. We've argued everything. We think we've got it, and the form is going to get submitted. Then you go out to the formal charge conference and the appellate lawyer just starts reading, as fast as they can, every different objection, including things that were never raised in the informal charge conference where you wouldn't have had an opportunity to actually address it. So another way a young lawyer can be helpful is as you're working through the informal charge conference of really taking notes of what issues were raised and what were not. Because I will tell you, one way to upset a judge too is to raise something at the formal charge conference that was never raised before, to allow the parties an opportunity to discuss it, see if they can reach an agreement, and allow the judge time to actually think about the issue and see if there's a change to the charge that needs to be raised. So I think there's a lot of really good ways that a young trial associate can be particularly helpful in the charge conference.
Great. And I think one of the issues during our mock presentation was unexpected emergency. And I understand David had some video issues caused by landscaping nearby. But are you there, David?
I'm back. Yeah, the neighbor's leaf blower showed up and I was outside. Man, he was blowing a lot of leaves. So I had to evacuate where I was. My apologies.
Well, hopefully your piles of paper are still in one piece. But
I jumped on them to save them from injury.
What is your perspective, David, on how young lawyers can get involved at the charge conference?
Yeah, so everything, the points made up to this, or I really have very little to add, except I would say this. If you're a young lawyer and you're at the charge conference and you know about issue X because you researched it, and so everybody's talking about issue X, talk. There's nothing wrong with your voice. And it's people frequently think that if they whisper in the ear of the appellate lawyer, it will like get better when it comes out the other end. That's not true. It gets worse because I can only hear one thing at once. So if you know about it, tap somebody on the shoulder and say, do you mind if I get going on X? I got this to say. Go. They're going to want you to go. 99% of judges welcome that. They want to get it right. They're not going to be hung up on only one person can talk if someone's got something to say. So don't be feeling like you need to hide. If you've researched it, you know what you're talking about, talk. This is your chance.
And Justice Mulberg, what is your perspective on, more than one lawyer talking and junior lawyers getting involved and speaking at the charge conference?
Well, I was always excited in the trial court to see the young lawyers because I love the civil trial system in our state. And, did it myself and was a young lawyer for a number of years before I became an old lawyer. And so it's a very exciting thing. But judges, typically judges are not going to mind at all during the informal conference or the formal charge conference of more than one lawyer talking per side. There are some judges who do, but my view was always, look, this is outside the presence of the jury. It's called the court's charge. So I want to have as much information and knowledge as possible when I put together that final charge and put my name on it. So that's something that's never bothered me at all.
Thank you. And one of the other questions we've received from the audience is about preserving error. So David and then Morgan, could you walk us through a little bit of how you go about preserving error? I know that can be awkward because the court's going to at the end of the day rule against you, but could you kind of talk us through the nuts and bolts of that?
Three things I'd say. First, figure out if you have the burden on it or it's your thing, your inferential rebuttal, if it's that kind of thing. If you have the burden on it, you probably need to submit something to preserve error. If you don't have the burden on it, an oral objection that is overruled is probably sufficient. If you submit something in writing, you need to hand it to the judge and they need to mark something on that. The rule requires that. It seems a little weird, but everybody's used to it. The rule requires that. So that's what is it that you need to submit, have some idea of that in your head. And then I strongly suggest for things that you're objecting to, that you consider having a set of comprehensive written objections in advance of the formal charge conference that you've had a chance to think through, carefully phrased, be sure you aren't missing anything. You can do some last minute edits and whatnot, but doing that and satisfying everyone that you hadn't slipped anything new in there, this really is what you've talked about, can save a lot of time and be a lot more accurate than getting up and just sort of reading a bunch of stuff off really fast and annoying people like Leslie.
Morgan, what about you?
I think number one thing is don't forget that what happens during the informal conference doesn't matter. And you've got to make sure that ultimately, if you need to object to something, if you need to preserve something, you better do it during the formal charge conference on the record. And I think to the extent that you're not submitting written objections to something, if things are just really moving quickly and rapid fire and you need to just orally recite your objections during the formal charge conference, I would recommend that you write them out and read them slowly so you don't sound like a crazy person and make the court reporter mad. But I would read them out or at least work off of some type of script so that you feel confident that you've not left anything out, because it is so important. You can blow the whole case just by messing up something in your jury charge. So I personally like to have the safety blanket of something in front of me so that I know I've covered everything.
Great. And Leslie, I think David mentioned you. And so like a presidential debate, I want to give you a chance to respond. But what's kind of the judgment calls that trial counsel needs to make before kind of pressing forward with an issue in the jury charge?
Right. A lot of times the approach is, okay, what does the PJC say? Checklist, we're just pulling it all over. We put all the definitions in. And what you should really be looking at is, what do I really need? What is, I mean, to David's point earlier, what does the fact finder really need to consider in order to answer this question and get rid of all the other stuff? And if the other side wants to submit a question or instruction that you don't like, but they might be entitled to, I mean, sometimes it is a judgment call. You say, look, I think that I'm going to win this case. And so I'm not going to give them an appellate argument. You want to give that instruction, you want to give that extra, affirmative defense. I'm going to let you submit it even though I don't think you're entitled to it, because when I win this, I'm going to keep it on appeal.
George, can I add one other preservation point very quickly? If you submit things for the judge, submissions for the judge to rule on, make sure you know where those go. You don't want them to just, the judge to sign them and they go off in the trash somewhere. Say on the record where they're going, that there's someone's going to go put them in the court file, or they're going to get marked as an exhibit at the hearing or something. But as long as they're somewhere, you're good. But if they just sort of wander off, then it's as if they never happened. And in the rush of business, that can happen. So just don't let them get away from you.
All right, great. Well, I'm sure I certainly learned a ton today, and I don't want to run too far over. We've answered both of the questions that we've received during the course of the presentation today. Thank you, everyone in the audience, for attending today's webinar. And thank you to Justice Mulberg, who looks like he's back after some technical issues, Leslie Shigaris, Morgan McFeeters, and David Cole for their time today. And special thanks to Marifera Aceves, Jay Spring, and Alex Reisinger, committee members who assisted in the preparation of today's program. Also, a quick announcement. The Dallas County George Allen Courthouse's jury proceedings addendum for the COVID-19 operating plan was recently approved, and the Trial Skills Committee may soon be hosting an interview with members of the Dallas Judiciary about Dallas jury trials in the time of COVID. So keep an eye out in your emails for that. This program was recorded and will be available soon online. Please remember to self-report your CLE credit to the State Bar. Once again, the course number is 174097829. Have a great day. Thank you.